So we're going to start the meeting. We are in public session. I shall wait for cameras. We have cameras. Okay, good afternoon. We have a quorum. We are in public session. I want to remind members and visitors to turn their mobile phones off. Our meeting has been convened today to discuss the policy issues arising from the Cemetery Management Bill 2013 and related matters. Now, at 3:15 there's going to be a minute's silence in the chamber in an expression of sympathy to the victims of the Paris atrocities. And we're going to join in that here at the committee. So I want you to just put you a notice for that 3:15. It is proposed that if not previously concluded, this session will have to be brought to a conclusion at 3:30. The Finance Committee are coming in here to the Finance Bill, and because of the late start, we're under a particular time restriction. Now, I would like to welcome the following witnesses to the meeting. From the Department of the Environment, we have Mary Hurley, Assistant Secretary, Community Division; David Dalton, Principal, Community Division. From the Competition and Consumer Protection Commission, we have Ms Isolde Goggin, the Chairperson; Mr John Shine, Director of Advocacy and Market Intelligence; and Ms Hyan Wang, Head of Unit Consumer Enforcement Division. From the Irish Monumental Firms Association, we have Mr David Pearce from Pearce Monuments, Mr John Sweeney from Craft Monuments, and Mr Jerry Brennan from Headstones Ireland. From the Dublin Cemeteries Committee, we have Mr John Green, the Chairman, and Mr George McCullough, the Chief Executive. The Department of Jobs, Enterprise and Innovation have supplied a submission. I wish to draw your attention to the fact that by virtue of Section 17(2) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect of their evidence to this committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise nor make charges against any person, persons or entity by name or in such a way as to make him or her identifiable. It is proposed that the opening statements and any other documents that may be provided by witnesses may be published on the committee website after the meeting. Is that agreed? I'm now going to call on Ms Mary Hurley from the Department to make her opening statement.
Thank you. I want to thank the Chairman and members of the Joint Oireachtas Committee on Environment, Culture and the Gaeltacht for inviting the Department of the Environment, Community and Local Government here today to discuss the policy issues arising from the Cemetery Management Bill 2013. I'm accompanied today by Mr David Dalton, Principal Officer in the Department's Community Division, with specific responsibility for inter alia, local government community services and the regulation of local authority burial grounds. The Department of the Environment, Community and Local Government has policy and legislative responsibility in respect of the regulation of local authority burial grounds. This responsibility covers a range of technical aspects related to the operation of burial grounds, but does not extend, however, to matters relating to funeral industry generally. The main legislative provisions in respect of burial grounds are contained in, firstly, the Public Health Ireland Act 1878, as amended by Part 6 of the Local Government Sanitary Services Act 1948, the Local Government Act 1994, and finally in the Rules and Regulations for the Regulation of Burial Grounds 1888 and the relevant amending regulations. The legislation provides that local authorities are burial boards for their respective functional areas. They have sole responsibility for providing, managing, regulating and controlling burial grounds in their areas. In this respect, there has been gradual devolution of functions from central to local government over time, with almost all functions relating to burial grounds exercised locally by local authorities at this stage. The underpinning legislation has been in place for some time, but it has served us well and continues to do so. While there have been calls to review the legislation in recent times, it has remained unchanged as the changes proposed were outside the Department's policy and legislative remit. I believe that this is also the case with the matter before the committee today. The Dublin Cemeteries Committee was established as a body corporate by the Dublin Cemeteries Act 1970 and is a registered charity for tax purposes. It currently owns and operates a number of cemeteries in Dublin City and County and has incorporated a number of limited liability companies for the purposes of carrying on certain ancillary funeral-related businesses. A Supreme Court decision in 2009 reaffirmed the capacity of the committee in this regard. Neither the Department of the Environment, Community and Local Government nor Dublin City Council have any function in relation to or any direct control over the operation, management, regulation or otherwise of Dublin Cemetery Committee or, for that matter, the business of any other private cemetery operator. As outlined in the explanatory memorandum, this bill has been introduced primarily for the purposes of regulating competition. At its heart, therefore, the bill seeks to address a market regulation and competition matter in the funeral industry and to level the playing field between private businesses. The Department has no policy responsibility in this regard, and the proposal to vest responsibility for such a regulator in the Minister for Environment, Community and the Local Government therefore is not consistent, in our view, with the scope of the Minister's responsibility vis-à-vis the operation of management of burial grounds. As stated, the primary purpose of the bill is to provide for the establishment of a cemeteries regulator. Firstly, there is no policy or other need for a cemetery regulator in respect of local authority or ecclesiastical authority burial grounds, which constitute the majority of burial grounds in the state. Secondly, the introduction of a regulator for such a limited number of operators, and at a time when government is actively pursuing measures to reduce the number of state agencies and control the number of state employees, would appear to run counter to government policy to reduce the number of such authorities. Thirdly, a regulator would require a staffing structure and other necessary administrative supports, all giving rise to a potential significant cost to the Exchequer. And finally, given the clear purpose of the proposed regulator to regulate competition between private businesses, it appears to duplicate the statutory remit of the Competition and Consumer Protection Commission. Indeed, the Commission has already responded to a complaint of anti-competitive practices by Dublin Cemeteries Committee and made recommendations in this regard. In conclusion, I do not believe that the competition matters the bill seeks to address comes within the policy or legislative responsibility of the Department of the Environment, Community and Local Government. For this reason, I have not dealt with the technical or legal issues and other matters of concern arising from the bill. However, I am happy to briefly detail these if it would be of assistance to the committee as part of a broader discussion on the bill today. Given the breadth of policy and technical issues arising from the matter we are here to discuss, I believe that a wider consideration by other departments of the proposals reflected in the bill is also imperative. I'd like to thank the committee again for its invitation to participate in today's discussions. I hope the foregoing will assist the committee in its deliberations, and both my colleague David Dalton and I will be happy to deal with any queries that might arise in the course of subsequent discussions and which come within the remit of our department. Thank you.
Thank you, Ms Harley. I'm going to call on Mrs Dalton to make her opening statement.
Very much, Mr. Chairman, and thank you to the committee for inviting us. We're very pleased to be here on the occasion of the discussion of the Cemetery Management Bill 2013. I'm accompanied today by my colleague John Shine, who's Director of our Advocacy and Market Intelligence Division, and Haiyan Wang, who is Head of Unit in our Head of Investigation in our Competition Enforcement Division. Just to explain a little bit about our role, we're a relatively new organisation. We were formed in at the end of October 2014 from the amalgamation of what was then the Competition Authority and the National Consumer Agency. The mission of the Commission is to make markets work better for consumers and businesses, and our vision is for open and competitive markets where consumers are protected and empowered and businesses actively compete. So we've brought together the competition and the consumer protection roles of the two legacy organisations there. I just wanted to tell the committee a bit about our past involvement in the sector and then move on a bit to our views on the question of regulation. Funeral-related services are something that they're a little bit different from the run-of-the-mill services that people buy. In a lot of, if you look at our website, which is ccpc.ie, a lot of our advice to consumers is telling people to shop around. You can't say that to somebody in a situation of bereavement. So they're by nature very sensitive purchases. They're purchases that consumers have to make in very difficult and very stressful circumstances. They may be particularly vulnerable in comparison to other purchases. They're unsure about what exactly they need to do. They may be very dependent on the service provider, which is normally a funeral director or a provider of cemetery services, to guide them through the process. As such, it's very important from our point of view to have transparency and compliance with competition and consumer law in the sector. From an enforcement point of view, the Commission conducted a detailed investigation over a number of years into alleged anti-competitive practices by Glasnevin Trust. This was concluded to our satisfaction in March 2015 with the agreement of Glasnevin Trust to a number of remedial measures. Details of the case are available on the website, but I just summarise, if I may, the main aspects. The case arose from a complaint received in November 2011, where it was alleged that Glasnevin Trust and its subsidiary Glasnevin Cemetery Monument Works Limited, GCMW, were engaged in anti-competitive practices which were designed to put competing headstone providers in particular at a competitive disadvantage. It was alleged that this amounted to an abuse of dominance by the Trust contrary to the Competition Act. We did a detailed preliminary assessment and subsequently a formal investigation. We engaged with Glasnevin Trust and we sought and secured a number of remedial measures from them. The measures related to the provision of burial plots, headstones and headstone foundations, and they were designed to mitigate the alleged anti-competitive practices and ensure the protection of consumers and increased transparency. The measures included, number one, Glasnevin Trust to make its prices more transparent to consumers, making it easier for consumers to find a price list for burial plots and foundation fees on their website and in their offices. Number two, given that many funeral directors obviously are acting on behalf of the bereaved families, that Glasnevin Trust take measures to ensure that the funeral directors inform consumers of the separate cost of the foundation fee, because this has been kind of an issue, the degree of transparency around the foundation fee. So, for instance, before applying for burial services in DCC cemeteries, the funeral directors were required to confirm to DCC that they had informed consumers of the foundation cost. Thirdly, Glasnevin Trust to treat competing headstone providers in an equal and non-discriminatory manner in terms of waiting times for permits and foundations, access to the cemetery and regulatory requirements. And finally, Glasnevin Trust to allow competing headstone providers to advertise in their promotional brochures subject to payment of the same fees as would be payable by GCMW, their own subsidiary, for that kind of advertising. So based on these measures, we were satisfied to conclude the investigation in early 2015 without any further action being required. The Commission also corresponded with the Irish Monumental Firms Association, setting out our position on the issues that had been raised. Mindful again of the potential vulnerability of consumers at a particularly stressful time, we also provide information to consumers in a dedicated area of our website called Planning a Funeral, and we've recently added additional material in relation to succession planning. We operate a helpline for consumers which deals with over 50,000 contacts per annum, from people ranging from very general inquiries to specific complaints alleging breaches of consumer law. On average, we would get about 10 contacts per annum in relation to funeral-related issues. There's no huge pattern there. The issues raised seem to be one-off issues, and we haven't received anything that would suggest that there are substantive issues relating to breaches of consumer law. So that's the history of our involvement in the sector from the competition and consumer side. I suppose, in summary, I would say that we feel that because our remit covers the entire economy, in a sense, if there are competition issues or consumer issues, we're already there to deal with those as part of our existing remit. Turning to the necessity for regulation, we note that the purpose of the bill is to establish a cemeteries regulator, to provide for the licensing of cemetery authorities and to specify management stipulations for such authorities, to promote competition and to provide for related matters. In relation to matters relating to competition law and consumer welfare, as I said, which are already within our remit, we've no information that would indicate that there are substantive issues out there which merit the creation of a new regulatory authority. That's not to say that issues causing detriment to consumers might not exist, but rather that we don't see that a sufficiently strong case has been made to justify the proposal for a specific regulator. As a general principle, we consider that regulation should only be adopted as a last resort where there are very serious shortcomings in a sector and in circumstances where existing measures have proved incapable of addressing such issues. Regulation can go too far. It can impose restrictions on entry to a market that can actually damage competition, leading to cost increases, inefficiencies, lower service quality and general detriment to consumers. Regulation itself has to be paid for. My colleague from the Department of the Environment mentioned that that might cost money to the Exchequer, but in my experience, usually a regulator for a very specific sector is paid for by a levy on industry, a levy on the businesses that are in that sector, and that in itself can lead to increased costs, and the costs may outweigh the benefits. So we would recommend, I suppose, that any proposal to introduce new regulatory structures should be progressed only after very careful consideration of the necessity for them and the implications of such an initiative. If I might turn to a couple of specific concerns that would strike us in relation to the current proposals. We understand that the key concerns informing the bill relate to alleged anti-competitive practices in the cemetery industry, and in particular to Glasnevin Trust's engagement in ancillary commercial activities, i.e. other commercial activities where there are also other firms engaged in it. We would consider that there's a danger of duplication of existing statutory functions. As I say, we're the statutory authority with responsibility for enforcing competition law and consumer law in the state, and we would very much welcome anybody who has any concerns in relation to potential breaches of either competition or consumer law to come and talk to us and bring those to our attention. We do have the power to investigate. We have done that in the past. The bill envisages a role for the proposed regulator which would duplicate some of those statutory functions. The other point we'd make is that parties do have a right of private action before the courts, so it's not always necessary for a regulator to act on behalf of aggrieved parties, that parties can take action themselves, certainly in relation to competition law and in relation to some aspects of consumer law. Effectiveness and proportionality, again, there's an issue of the coverage of the proposed bill. It defines a cemetery authority as being any company, committee or body other than a local authority or a town or borough council or an ecclesiastical authority that is engaged, whether pursuant to statute or otherwise, in the management, operation or occupation of a cemetery. So our understanding is that Dublin is a specific case, and a lot of the cemeteries outside of the Dublin area are either local authority owned or ecclesiastically owned, so they wouldn't be covered by the bill. So within the Dublin area then it seems that the impact would mainly be on Glasnevin Trust. The bill also proposes to restrict the regulated entities with charitable status from engaging in ancillary commercial services at its cemeteries. Again, Glasnevin Trust appears to be the only cemetery operation with charitable status in the Dublin area. And I mean, I think we have to say that engagement by charitable organisations in commercial activities, it's not in itself anti-competitive. We have to bear in mind that operating a cemetery is a very, very long-term business by its nature. In some cases, the trusts or the organisations involved are required to maintain them into perpetuity. So it doesn't seem unreasonable for the operator to try to find some kind of ancillary commercial activities to fund the maintenance of cemetery grounds that no longer perhaps generate sufficient income from burial plots, particularly the older ones. The funding requirement is likely to be higher for cemeteries that are of a historic nature and are of generally higher maintenance, not so easily done as the modern ones. As I mentioned when I was talking about the four measures that had been agreed with Glasnevin Trust in order to promote competition and protect consumers, they have undertaken to treat competing headstone providers in an equal and non-discriminatory fashion, and we'd be very happy to engage with any of the other cemetery operators if similar issues arise elsewhere and to explain to them how they can meet similar requirements. In conclusion, Chairman, we would say that regulation should not be an end in itself. In considering any proposals for additional regulation, any perceived failings in the sector should be clearly identified, and it should be clearly demonstrated that such issues cannot be adequately addressed within the existing legislative environment before we contemplate additional regulation. Any such regulation will come at a cost which will, no matter how it's constructed, it's likely in the end to be borne by the consumer. We think that any proposal for further regulation would merit careful consideration and the conduct of a regulatory impact assessment. And in relation to the cemetery sector, we're of the view that the case for further regulation hasn't been sufficiently articulated, and that further examination would be required before proceeding any further. Thank you very much.
Thank you, Ms. Coggan. No, Mr. Pearce.
Mr. Chairman, members of the Oireachtas and invited guests, we, the Irish Monumental Firms Association, are here to seek help in achieving a level playing field, fair competition, fair procedures and an end to a charity dominating the headstone trade. Cemeteries by their nature are anti-competitive. Everybody goes to their local cemetery. If it becomes ridiculously expensive, the market does not correct itself. That's why we need a regulator. Planners will not give permission to open a new cemetery in a locality where an existing is still viable. Therefore, the business of operating a cemetery is outside the normal checks and balances of a competitive environment. We are a group of 10 headstone businesses based all over Dublin. We are struggling to survive in business, most of us having our turnovers decimated. The Dublin Cemeteries Committee trading as Glasnevin Trust are the main reason why we are on the verge of collapse. The DCC are a private statutory body and a charity controlling 4 of the largest cemeteries in Dublin, namely Glasnevin, Palmerstown, Newlands Cross and Dardistown at Dublin Airport. It does not pay corporation tax, we do. It does not pay rates on their showrooms and factories, we do. The DCC use burial data to send brochures to relatives of the deceased. We don't have access to that information. They have huge displays inside their cemeteries and their registrars double up as salespeople, pitting them against us on a daily basis. Up until recently, they received 12.5% commission when selling a grave or a headstone. Some of the staff can have wages of €2,000 a week. They insist on doing foundations for our headstones, charging us €1,000 in Glasnevin. We've offered to pour these foundations for €80. They charge us €500 to spend a day working in their cemetery. We have to pass these outrageous fees on to the bereaved of Dublin. They insist on doing all work on stone cremation walls. We are not allowed work on any cremation plots, even though this is the only growing part of our business. They have begun to sell pre-erected blank headstones on graves. This totally excludes us from the market. No other cemetery operator anywhere we have found allows this. So far, 7 monumental firms within proximity to Glasnevin have closed. Just last year, Farrells of Glasnevin, 126 years old, had to shut down. We are not allowed to meet potential customers in their cemeteries. We are not allowed to take photographs of our completed work. The ECC have over the years barred 7 Dublin monumental firms for operating in their cemeteries for spurious reasons. These firms have never been in any dispute or even queried by any other cemetery owners ever. Kerry County Council operate over 130 cemeteries, Fingal County Council over 30, and none of them have ever had any reason to ban firms or men from going about their business. The evidence strongly suggests that when a body is both regulator and competitor, it cannot be trusted to be fair and impartial. There are lots more examples of Dublin sculptors, abuse of Dublin sculptors, far too many to mention here. The firm I represent have seen our turnover drop to 350,000 from 1.3 million. It could be said, through loss of earnings, Dublin sculptors have contributed more to Glasnevin than anybody else. Glasnevin Trust have taken our trade, aided and abetted by the state. The Oireachtas has given the DCC a far better deal than Apple or Google received. Theodore Roosevelt, the 26th US President, said 115 years ago, "Artificial bodies depending upon any statutory law for their existence or privileges should be subject to proper governmental supervision. In the interests of the whole people, the nation should assume power of supervision and regulation over such bodies. This is especially true where the corporation derives a portion of its wealth from the existence of some monopolistic element or tendency in its business." Over the years, we have written to the DCC, we have suggested arbitration, we even suggested a yearly voluntary contribution by us if they stop selling monuments. The last correspondence we sent to them was nearly 2 years ago. They answered us with a solicitor's letter sent to our individual homes and business addresses, not our association's office, threatening to sue us personally if we continue to protest about them. As we said in our opening statement, the DCC now own and control 5 cemeteries. When they double in size again, we will no longer exist. They are now by far the largest provider of burials and cremations in Ireland. Their monumental firm is also the largest in Ireland. They now sell headstones tax-free and rates-free all over Dublin and beyond, not just in their own cemeteries, but in cemeteries from Balbriggan to Bray. They have now branched into boulders for housing estates and nameplates for houses, all tax-free. We are asking the Oireachtas to enact this cemetery management bill as it is the correct thing to do. New South Wales in Australia and New Zealand have recently introduced new cemetery regulators. In the Dáil debate, some TDs use the phrase "not another quango," but the DCC is the oldest quango in Ireland. They are a body of perpetual succession with no role for a government minister. Is it a case of swapping an unaccountable quango for an accountable one? In the 1970 DCC Act, the Oireachtas entered into a bargain with the owners of Glasnevin Cemetery, conferring powers on them but with no safeguards for anybody whose private interest could be destroyed by them. But to compound the problem, you, the Oireachtas, allowed them become our competitors with a tax exemption and a regulator who are not answerable to any power in the land. Heretofore, when the state interfered in a trade or business, the affected parties received some sort of compensation. For example, farming, fishing, turf cutting, and even taxi persons received tax concessions after deregulation. Members of the Oireachtas, make no mistake, you have interfered in our trade and you must make it right. We are not looking for compensation, we just want fair play and the opportunity for our firms to survive. We sculptors are not out of step here, however the Oireachtas is, because no other country in the world allows a charity sell headstones. Now, the Competition and Consumer Affairs person said that charities have to raise money. Well, Glasnevin are members of what's called the Historical Cemeteries of Europe, 150 cemeteries. The other 149 do not sell headstones. They think it's unethical and immoral. They don't interfere in the trade. To finish, I'm just going to give you, I had a lot written, I'm going to change. I just want to read one thing to you. In August 1988, at the age of 24, I set up a headstone business in Swords, County Dublin. Business went very well, and over time my turnover had reached 1.3 million with 10 employees. I erected headstones in cemeteries in North County Dublin and North City Dublin. The Dublin Cemeteries Committee opened a large cemetery in Dardistown just beside Swords. At the time, I considered this to be a good opportunity. 2 years after opening the cemetery, the DCC erected, just inside the main entrance, a huge display of new monuments for sale to the bereaved. They erected signs suggesting that when you purchase from them, the graveyard will be better maintained than if you purchase from me or my colleagues. My first exposure to the power of the DCC was when I met a family in the cemetery who wanted to see some of my recently erected monuments. I received a phone call the next day to say that if I ever met a family in the cemetery again, I would be barred from all of the DCC cemeteries. Most of the members of this Oireachtas committee will be familiar with their local sculptors and local cemetery. Imagine if he or she was not allowed to discuss a headstone with you or your family in a local cemetery. It does not happen anywhere else in Ireland. It is why Glasnevin Trust, as they call themselves now, cannot be both regulator and competitor. A few weeks later, I was taking some photographs of my recently erected monuments. Again, the next day, I received a phone call saying no photography was allowed in the cemetery. This was all the more galling as Glasnevin Trust have pictures of my work all over their offices. Sculptors all over Ireland inscribed their trade name and phone number in small letters on the side or base of their newly erected work. This is historically the best way of selling monuments. I was told not to put my phone number on monuments or I would be barred. Again, this does not happen anywhere else and is why Glasnevin Trust cannot be both regulator and competitor. Finally, I would say, you say we have room to go to the courts. Glasnevin had an Irish stone rule, and I won't bore you with it, but they dropped the rule when I took them to court. I was left paying €16,000 to a new business. I was a new business. There's no in the legislation of the 1970 Act. There's no internal safeguards for us. There's no external safeguards. We are not under, the Competition Authority have told us they can't help us, that it's state aid, it's not really competition. The Revenue Commissioners won't talk to us, they say client confidentiality. We don't want to know anything about the tax fares of Glasnevin, but the revenue, we're just saying a charity shouldn't be selling monuments. You talk about charities trading. Glasnevin, they do not have to sell headstones. There's lots of other monumental sculptors. They can raise their money other ways. How come 149 other members of the Historical Cemeteries of Europe think it's unethical to sell monuments? Thank you.
Thank you, Mr. Pearce. Mr. Green, to make your opening statement.
Mr. Chairman, first of all, may I express our condolences to you on your recent loss. My name is John Green. I am Chairman of Glasnevin Trust. Glasnevin Trust is the business name of Dublin Cemeteries Committee, established under the Dublin Cemeteries Committee Act of 1970, which followed on from the earlier 1846 Act. Glasnevin Trust manages the operations of Golden Bridge, Glasnevin, Palmerstown, Dardistown and Newlands Cross cemeteries. It operates solely by reference to the public interest in the provision of burial grounds and cremation facilities, as well as the maintenance of Ireland's historical national cemeteries at Glasnevin and Golden Bridge. Glasnevin Trust is run by an executive managed team and Dublin Cemeteries Committee. I'm today joined by George McCullough, the CEO of the Trust. Glasnevin Trust manages the burial and cremation of circa 4,000 people annually, now running at a ratio of 50-50. This accounts for less than 30% of the burials in Dublin and the immediate surrounding counties. The remainder of burials in the Dublin area are carried out in cemeteries owned and operated and subvented by local authorities or in a few privately run cemeteries. Glasnevin Trust also maintains and preserves the considerable heritage assets in Glasnevin Cemetery, which has become the focal point for many of the commemorative events for the decade of centenaries. More recently, Glasnevin Trust has opened the multi-award-winning Glasnevin Museum as a major educational and tourism centre. The museum attracts over 100,000 visitors annually and is a significant boost to tourism and the economy on the north side of Dublin. At our initiative, the new DNA body, Dublin North Side Attractions, has been developed and been launched at the World Travel Market 2 weeks ago by the Minister for Transport, Tourism and Sport, Paschal Donoghue. Glasnevin Trust employs over 100 people in Dublin. Companies owned by the Trust also offer florist and monument work services to the bereaved, competing in a market where over 50 registered monumental sculpture companies and hundreds of flower sellers operate. Glasnevin Trust, in the absence of any other significant development of local authority cemeteries in Dublin region in the past 30 years, has developed 3 cemeteries: Palmerstown Cemetery in 1990, Darnestown Cemetery, and in 2000, Newlands Cross Cemetery, while simultaneously introducing and developing cremation in the Dublin area in 1982, establishing the first crematorium, Glasnevin Crematorium Limited, and in 2001, Newlands Cross Crematorium, with Darnestown Crematorium scheduled to open in 2016. Glasnevin Trust is a statutory and voluntary not-for-profit body, originally established by Daniel O'Connell in 1828. Glasnevin Trust, in recent times, with the invaluable assistance of the Government and the OPW, has overseen the restoration of Glasnevin Cemetery from a dilapidated state to the sanctuary of peace, dignity and reconciliation it is today. The Trust role remains, as it was handed down from Daniel O'Connell, to bury people of all religions and none, and to ensure that we bury and cremate the dead with dignity and respect. We believe the ultimate dignity for the deceased is paramount, and burial grounds need to be maintained and funded on a sustainable basis. Indeed, many burial grounds operated by local authorities can only survive with direct, significant financial subvention from the local authority budgets, which in the past year in Dublin, in its hinterland, was in the order of €2.5 million, and across the country amounted to some €10.8 million. I have with me the figures, the breakdown of these. In addition to providing burial service, Glasnevin Trust has been working closely with the state and playing its part in the decade of remembrance. Glasnevin Trust, true to its mission of serving people from all creeds, beliefs and walks of life, has been central to a number of state commemorative ceremonies. These have ranged from the commemoration of Irish men and women who lost their lives in the First World War to Collins and Griffith. And just this summer, the state remembrance of the centenary of the burial of Jeremiah O'Donovan Rossa as the opening centrepiece for the 1916 commemorations. In addition to that, the 100th anniversary of Cumann na mBan and a multiplicity of commemorations of national importance are held on a regular basis at Glasnevin Cemetery. This work will continue right through the 1916 centenary commemorations, with a number of major projects scheduled, among them being the Necrology Wall 1916 to 23, which will remember in a totally non-judgmental manner all who lost their lives during the struggle for independence in the period 1916 to 23. In addition, Glasnevin Cemetery will be the site for the opening of the governmental commemorations on Easter Sunday morning, 2016. I give this by way of background as an explanation to the role of Glasnevin Trust in the life and history of Dublin and its people since its foundation in 1828. Turning specifically to the purpose of this Oireachtas Committee, to elicit the views on the policy issues rising from the Cemetery Management Bill 2013 and related matters. I understand that this is a private member's bill that was advanced by Deputy Maloney. There are a number of important regulatory issues concerning burials and cremations which have not been addressed in this bill. For example, Glasnevin Trust has identified the need for a new regulatory structure for cremations in Ireland. At present, this is totally unregulated, despite its increasing demand. In Dublin last year, 50% of the people were cremated. We have previously engaged with government from TD to ministerial level for both cemetery regulation and proper cremation regulation, and believe this is an area being progressed by the Department of Environment, Community and Local Government. The bill as set out has a very narrow focus and does not address the broad issue impacting on burial grounds and cremation services. It solely concentrates on a small number of burial grounds, including private burial grounds, private family burial grounds run by a charitable trust, Glasnevin Trust and Jewish burial grounds. The Glasnevin Trust Cemetery, together with Mount Jerome, Mount Venus, Kilmashogue, Dolphin's Barn, Ballybock and Woodtown, would be covered by the legislation, but all others would be expressly excluded. The bill proposes to exclude from regulation local authority cemeteries, ecclesiastical and religious orders cemeteries. Thus, the bill, as a matter of fact, proposes to regulate for less than 10% of the burials in the state and a tiny percentage of all burial grounds. The policy basis for such a narrow focus has not been made clear. During the Dáil debate on this, certain comments were made about Glasnevin Trust, which is important I address, as many are based on a very distorted and selective view of our operations. At the heart of these complaints is a protracted challenge that the Trust has faced from an individual monumental sculptor, supported by a minority of those in the monumental industry, who contend that the matter in which Glasnevin Trust regulates the cemeteries we operate is illegal. They have variously claimed that Glasnevin Trust has breached Irish and EU competition law, and that the Trust was generally operating outside the law. They have brought their case to the European Commission, the Irish Competition Authority, the High Court and the Supreme Court, who have all ruled in our favour. Latterly, following a further complaint to the Competition Authority in 2011, now the Competition and Consumer Protection Commission, the Commission stated that it had a number of concerns and made 4 recommendations to Glasnevin Trust, all of which have been fully complied with. In conclusion, Mr Chairman, I would like to reiterate the absolute commitment of Glasnevin Trust to continuing to bury and cremate people of all denominations and none with dignity. We will ensure that all of our burial grounds in our care are maintained to the highest standards, so that the family of the bereaved will continue to have a peaceful and compassionate environment in which to mourn and remember their loved ones for generations to come. Or, as our mission statement says, to preserve the past for future generations.
Thank you, Mr Green. Deputy Eamon Maloney.
Very much, Chairman. And can I thank the previous speakers for their contribution, etc. Firstly, can I just say that, in fact, we wouldn't be here discussing this issue at all if there wasn't a problem, if there wasn't an issue within the industry, the headstones, etc. We wouldn't be having this discussion. Secondly, quite rightly, Ms Hurley, in the beginning of your contribution, quite rightly stated that the responsibility for graves, etc., in Ireland is a direct responsibility of the Department of Local Government, etc., etc. So, can I just say, and I'm not blaming you for the sins of Queen Victoria or Daniel O'Connell or anyone else, but we wouldn't be having this discussion if historically the department had dealt with this, especially in 1970, when bill came before the House. A private act came before the House. In fact, I dare say that the people to my right and left here as legislators, if anyone was to try and introduce a private act in the House in this day and age, you wouldn't get as far as the stairs leading up to the Dáil chamber. But this was the sort of stuff of 1970s, where a private act to extend the protection of Glasnevin Trust, to extend their influence, their activity, etc., etc., it gave a protection that it gave to no other body. I mean, it's extraordinary that for all the good work that Glasnevin Trust were involved in historically, that they then moved into a position, I refer to the 1970 Private Act, which, by the way, was passed unanimously in the House, not drafted by any legislator in the House, drafted outside the House. Now, that speaks for itself. But what it did, and to sort of condense the argument, Chairman, what the 1970 Act did was that it bestowed on Glasnevin Trust a collection of new activities, could borrow, could, etc., buy property, etc., borrow money, etc., things it didn't have heretofore. And, of course, it allowed them then to engage in commercial activity. But the sort of people who've made their submission on my left, and all of their colleagues and all of the companies that have, since 1970, gone out of business, it bestowed a privilege on one body that was not conferred on other bodies. And what has happened since, especially since 1980s, early 1980s, been alluded to by one or two people, almost, in the Greater Dublin area, almost 20 companies have gone out of business. Companies who were engaged and who employed people, paid their taxes, etc., and who didn't have charitable status no longer exist. Now, without being too humorous about it, they didn't go out of business because people stopped dying. They went out of business because they couldn't compete. That's why they went out of business. And I cite as an example Mr. Pearce's letter in relation to the case in Swords. And that's, Chairman, the inequality of this whole situation. That's why we're here today debating this. Because not only has the department failed to regulate the unequal competition in this sector, where a registered charity, which has special tax status, which these men don't, is a trust. I don't know, other than one or two names, I don't know who's a member. I know it's perpetual, what's the word? Succession? Perpetuity. Wonderful. So you can't compare like with like here. And it is what happened in 1970 is something that we as legislators here, in the interest of fairness, we have to change that. It's not a simple matter for the department or to blame local authorities, although, again, historically, this should have been rectified because what's happened since 1970. But it's up to us now to rectify this. And this country has gone through great change and great turmoil, etc., etc. I hear the word quango being mentioned once or twice. So my difficulty with quangos is we haven't gotten rid of enough of them. But that's for another day. But we have to rectify this, and we have to rectify it on the basis of justice and fairness, that in any sector of Irish society, bestowing special private acts on one body should not be permissible. It's unfair, etc., etc., Chair. I leave it at that, and thank you, Chair, for your...
Thank you, Deputy. Deputy Doherty.
Thanks, Chairman, and thank you to everybody who've given testimony today. I have a couple of questions before I make my comments. Ms Hurley, the basis of your statement is that there isn't an issue anywhere outside of Dublin, and so therefore maybe that the legislation is misplaced for a regulatory body to be established as a national body when there only appears to be an issue in Dublin. And I fully concur. The purpose of the legislation was to try and address, from our perspective, having tried, and the gentleman to my left here who've given their witness statements today, having tried every other angle that they could try that was within their means to address the inequality in the Dublin market. But I'd ask you to go back